Good morning, Senna, and good morning to your colleagues. My national chairman and general secretary revoked my appointment.
Oh, okay. So until that is done, you still handle the responsibility of the director legal.
There's no automatic disqualification.
Well, he's acting CEO of the National Petroleum Authority. First, and in fact, the reason the Attorney General has had to do this has been because of this post made by Manasseh Zuri-Awone, where he insists that John Mahama is now the new is engaged in Operation Clear All Looters, not Operation Recover All Loot, Operation Clear All Looters. First, let me ask you whether you've seen that post and what you make of it.
Okay, so once again, good morning to your viewers online and your listeners. But I saw the post, and when I saw the post, I commented on it, not under it. I made the point that any accusation that John Dramani Mahama, the president, has engaged or is engaged in any act of clearing looters is regrettably born out of ignorance and mischief making. Why do I say so? Senna, you know, I have been involved at a personal level in some of these trials. Okay? And so, I have some personal information and detail about how some of these charges were preferred against individuals, some of whom I personally represented in court. Look, obviously, when Manasseh made that point, I said to myself, it may be born out of prejudice. Because what's the standard by which we are judging President Mahama? First of all, the issue of nolle prosequi is not new. In fact, it is statutory. Section 54 of the Criminal Procedure Act, Act 30, is clear. Section 59 of the Criminal Procedure Act, Act 30, is also clear on what constitutes a withdrawal of criminal charges. The two are not the same. When criminal charges are withdrawn after the prosecution had closed its case, the accused person benefits from what the lawyers will call ultra-four habits, ultra-four convict. What it simply means is that you become a beneficiary of the principle of double jeopardy. That is to say, those charges cannot be preferred against you again in future. If not, you suffer from double jeopardy. Right? Now, if it's just a filing of the nolle prosequi, the thing is, simply means, nolle prosequi simply means unwilling to prosecute. What it means is that in future, charges of that nature can be brought up against you. Okay? Now, Senna, if you look, and I want to address these matters one after the other. The specific case of the now governor of Bank of Ghana. And so now let me say this. The only basis on which Dr. Siama was prosecuted was because our vice president then Dr. Mahmoud Bamia, was angry that he, Bamia, had made certain accusations against the interoperability contract signed by the Bank of Ghana prior to 2016. And he, Isiama, came out to respond as the then deputy governor. That was the only reason why he was prosecuted. So now,
but that cannot form a basis of a charge being preferred against somebody. There definitely must be an act of indiscretion that leads to the charge being leveled.
no, so I'm coming there. So, the claim against Dr. Isiama was that the banking sector clean-up. Now, guess what happened? UT Bank approached the Bank of Ghana for some facility. Dr. Isiama received technical and whatever reports from the Banking Supervision Department of the BOG, because the request goes to them. They prepared all the proposals and scenarios and presented it to the three governors, the governor and the two deputies. One morning, they all had met and agreed that social and so bank should be given. Now you see, even though we call it liquidity support, it's actually a loan. You understand?
Yes.
And so these loans are heavily collateralized. The bank applying for it to put in a collateral. All these things were done. So why single him out for prosecution?
So this was about a loan that was given by the Bank of Ghana.
Yes.
A heavily collateralized loan.
Even though they call it liquidity support, it's actually a loan. And before you get it, you have to provide collateral. You understand? You have to provide a collateral. Because the bank also wants to be sure that you can repay.
Okay.
Then you come out and charge the man for crossing financial laws. A thing that is heavily collateralized. So, it will interest you to note that the prosecution department of the Attorney General's own now recommended that this prosecution is not sustainable. So, let's discontinue. The Attorney General then got very well and said, no, I'll continue. So now, is this how we treat a fellow countryman? So now,
but ultimately, the decision to prosecute is the preserve of the Attorney General, is it not?
It is not how ultimate it is. It is the soundness of it.
Are you saying his disagreement with the prosecution department had no basis or was not sound?
Absolutely. Because you see, prosecution is based on two things: evidence and the law. Evidence and the law. Now, in this case, you have charged the person for financial loss. That is imputation of recklessness. Is that not the case?
Yes.
Now, like I said, the processes generating to the request being approved and what have you generated from the Banking Supervision Department.
Okay.
Until it gets to. And in this case, 3 people took a decision. Now you single one out for prosecution. Is it how a discretion is exercised? So now. So what is this business of clearing agent? If, in all fairness, these are the facts. And again, the memo to discontinue the trial was not generated under John Mahama. The very people who commenced the prosecution.
So they are the ones who are telling you that discontinue this one?
Yes. And the memo is there. So now, you see the interesting aspect of this whole conversation. The memo recommending that the prosecution should discontinue is still there. Should we not, in good conscience, be asking why the Attorney General then refused to discontinue the trial? What public good was it going to serve? So now, what should we do to a fellow countryman? Possibly because we disagree with the politics of the person. Why? That's in respect of Christiana. Look, Colin Dada and others. Myself and my senior took Colin Dada to the police. In fact, we received an invitation through the speaker that the police CID, Forensic Financial Unit, are looking for Colin Dada, and that as an MP, they needed the speaker's intervention to see him. So now, at the speaker's conference room, that's where we met the police investigators. Look, by the time we were done, there was no bid to take Colin Dada to court. Do you know why? The contract itself was signed when he was not the minister. Okay?
Okay.
When he was not the minister.
Okay.
Now, contract itself specifies that the only person with the mandate to satisfy work done is the consultant.
Okay.
Now, you see, this is a criminal charge. Reasonable doubt. If you prove mens rea, a guilty man, right? You need to prove a guilty man. Now, guess something. In the course of the trial, the prosecution then decided to bring the chief director of the ministry as the first prosecuting witness. I was counsel for the Honorable Akufo-Addo Mensa, former Minister for Works and Housing. I hope you know him.
Yes, I've heard of his name.
Good. So, under cross-examination, I asked the first prosecution witness, also a reverend, that, Reverend, you were at the Ministry of Works and Housing. Is that correct? He said, that is correct. And I said, Reverend, as far as the Stadtwerke housing project was concerned, you were not involved in the execution. Is that correct? He said, that is correct. So I then further asked, at all material time to this trial, the person responsible for this project was the housing director in the ministry. Is that correct? That is correct. And you were then at the monitoring and evaluation unit. Is that correct? They said that correct. You had no personal involvement in this case. Is that correct? He said yes. I said, now, Reverend, have a look at Exhibit 8 and J. They looked at it. I said, is that the escrow management agreement for the contract for the housing project? He said, that is correct. I said, then go to paragraph 5.4 of the said exhibit and read to the hearing of the court. Mandate of the consultant. That's the heading. So I then asked him, now from what you have read to the court, the person responsible for the certification of work done is the consultant. Is that correct? He said, that is correct from what I am reading. I said, so who is the consultant? They said, AESO. So I asked him, is AESO one of the accused persons? He said, no. I said, now, Reverend, throughout this investigation, were you contacted by the investigators? He says, no. So when did the investigators first contact you? They started thinking about it. So I put it to you that they reached out to you after the charges were filed. Is that correct? Have you given written statements, either caution or ordinary statements to the investigators? He started telling stories. I said, show your written statement to the police prior to the charges being filed. The chief director was all over this. So I then asked him, so you would agree with me, would you? That throughout the investigation, they never even contacted you until they found the charges when they were looking for a witness. You was all over this. So I then asked, based on your own exhibits that were sent through you, was Collins Dada the consultant for the project? He says no. So I asked him, do you know the charges that have been presented against Collins Dada? He said, no. That's for the prosecutor. I said, but then do you know that you are the one that the prosecution has brought to court to come and provide the evidence in support of the charges, and you don't know the accusation for which reason you are in court? You also all over the place. And then prove it to him that you are the reason why these charges have been prepared, and that is why you are here testifying. They say, I'm not the prosecutor. I said, do you know that Collins Dada is charged for falsification of certificates? He said, I don't know. I'm not a prosecutor. So I said, now have a look at the charge. So I showed it to him. So when I showed it to him, I asked him, this charge is falsification of social and so. If I'm not the maker of the certificate, at least per the agreement, which is in the consultant, how come that you brought Elijah Collins Dada to to come and answer to something they didn't do? They said, I'm not the prosecutor. It's the prosecutor they decided what charge to present. Senna.
Mm-hmm.
Then the prosecution brought a second prosecuting witness. He was a special officer at the Ministry of Finance.
Okay.
Paragraph 9 of his witness statement, he says that I verify the certificates that are brought before payments are done. So I said, without your verification, will payments be done? He says, no. Did you verify the various payments made? He said, that is correct. Tenant. Is it not reasonable doubt? Huh?
But was reasonable doubt not for the judge to determine?
No, I mean, it's a skill. If you say a judge should be the one making a determination as to what constitutes reasonable doubt, then we are not safe. You see, the thing with criminal trial is that it's a binary conversation. It is or it is not. You get my point?
Yes.
It is either 0 or 1. So we call it fact. And the fact must be proved. In this specific case, You have charged me that I have falsified a certificate, right?
Mm.
But from the cross-examination that I told you, I am not the originator. So how can I falsify something that I didn't do? Meanwhile, you didn't even charge me with even the consultant. The consultant was not even brought to court at all. You know me, how I do my thing. I won't brag.
Mm.
But at least I know my, what shall I say, my skills. In fact, I remember by the time I was done with the cross-examination, my colleague for the other accused said, no, there was no point again. Because I took my time and exposed the prosecution witnesses. You understand? So how in good conscience will the Attorney General going to continue such a prosecution when this is on the record? True. Senna, the snake both here and there's something that happens. Senna, yes, you can disagree with me on why a certain payment was done for a transaction, but in and of itself does not mean a criminal offense. You get my point?
That's true.
So, in the split OBS matter, you know what the prosecution did? They brought witnesses to come and testify against an exposition. Now, do you know what happened in court?
No, you say.
The witnesses started embarrassing themselves. In fact, in the judge's ruling on the establishment of no case, do you know how he described the first prosecution witness?
No, please say.
Treacherous and dangerous character.
A judge called the prosecution witness treacherous and a dangerous character.
The first prosecution witness a treacherous and dangerous character. And this, I'm quoting the judge who came to court looking holier than thou.
I see.
To the judge again. He said the first prosecution witness, quote, was lying through his teeth. If you are any serious prosecutor, you need a form to withdraw the charge. So, I'm asking you.
I see. But was a submission of no case granted?
In fact, out of 27, it was there with one or something. In fact, some were acquitted and discharged. But clearly, if the foundational charge is dropped, what would the accused person be doing? Because you see, at the end, the evidence, assuming that the accused person had opened his defense, you are going to evaluate the entire case globally, not piecemeal. In your evaluation, would you take away the testimony of the first prosecution witness, who you yourself have described as a dangerous character and treacherous? Huh? No, sir, I'm asking you.
Anyway.
In fact, listen, the judge describes some of the charges as bizarre.
The judge thought the charges that had been brought against the accused person, some of them,
bizarre.
As for the Jakpa and the Opuni matter, I think I've had a couple of conversations with you on it. The Jakpa matter is famous for demands by many other lawyers for it to be dropped. The Opuni matter too, we had a conversation the last time. But there are those who talk about the optics. And I guess that's why Manasseh Azuri also wrote what he wrote.
There's nothing, listen, there's nothing optical about it. The expenses, you see, prosecution is expensive. You understand? Sometimes because we think they are public servants, we think it's not a cost. As somebody said, there's nothing like free lunch. There's a cost to the republic. So, in fact, there will be, they are approached by the attorney general to ask to discontinue these cases. It's a common sense approach.
Common sense?
Yes.
Then you're sure that if this evidence is put before anybody else, any right-thinking person, they will come to the same conclusion?
I didn't want to say it. You have used the right word, right-thinking person. Look at the how Honyenuga, the traditional authority for that matter, dealt with Opuni and Sebra Humbo. Why should we do this to our fellow countrymen? Why? Because of politics? I don't like you. I mean, look, let me tell you, Senna. Look at this scenario. You, Senna, you are a judge. You are sitting on my case. First of all, the case is being held at the High Court. There are 5 judges at the Criminal High Court. But for whatever reason, the Chief Justice there decided to go and bring a Court of Appeal judge to come and deal with me. Already, that sends a very wrong signal. It didn't end there. Whilst you were doing my case, do you know what happened?
No.
I further promote you to the Supreme Court. Is that the Queen people? So now, then, in the midst of you doing the case, you go and sit now as a traditional authority, Chief of Nyango. Guess what you decided to do? Akufo-Addo is the best president, even in Nkrumah, and the free SHS has done this, and the free SHS has done that, and it has done this, and this, and that, and that. This is a judge. Senna, this is a judge that the president, through his attorney general, has preferred criminal charges, and the charges were before him. Not praising the president who has just given him an appointment to the Supreme Court. Senna, why? 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 Is it human sacrifice? I bet those Jira then. That's the account should say they are torn one man. Look, this is a judge. Listen carefully, Osama. Throughout the prosecution case, you say a particular fertilizer is not efficacious. Who determines the efficacy of the fertilizer? Is it not the farmer?
Yes.
Is it not the farmer?
Yes. The one who is applying it.
Is it not the farmer?
Yes.
You, a judge, do you apply fertilizers? It is the farmer. Do you know that throughout the prosecution ever called even one farmer to come and say, this fertilizer that was used. In fact, the only person who came close to be a farmer was somebody who gave a statement to the police investigators. What was his claim? He said, listen, before I decided to use little of it, I was doing 50 bags. But when I used little of it, I got 52. Another farmer said, and in fact, there was an official report showing that by reason of the use of little of it, the cocoa ponds flowered, the cocoa leaves flowered so much, and that is the flower that creates the ponds. Their official report to that effect, prepared by an independent unit of cocoa board. Do you know what the judge did? Do you know what he did?
No, tell me.
When Opuni did the submission of no claim, the judge went up and said, even though he, the same judge, has admitted documentary evidence without objection from the prosecution, he is expunging it on the basis that it offends the guilty. Senna, is this not judicial language? You are doing it at the time when the accused person has no opportunity to say anything. Our laws not founded on the basic tenets of here before condemned. And that is why in a trial, in a trial, when evidence is being offered through a witness, the judge will ask, any objection to the person against whom the evidence is being offered has a right to object. In this case, listen carefully. In this case, my Lord Justice Onyenuga asked the prosecution, defense lawyer Samuel Kuju, Esquire, wants to tender these pieces of documents through your prosecution witness. Do you have any objection? Prosecution, my Lord, no objection. Then the judge knew by court. Social and so document is admitted as evidence. Gives to the class to mark it, and it is marked. It is a different thing if you didn't ask the prosecution. You can ask for the judge. You are an impartial person. It is the two parties that are before you. And that is why you ask them if they have any objection. They say we have no objection. And going to write your submission of no case, what do you do? You now raise the question to yourself. When you have not given the accused person the opportunity to rebut on the claim, now you know the curious thing. You struck out, expound from your record pieces of evidence that are exculpatory. And guess how he did it? Pieces of evidence that were tendered through the same prosecution witness, he left them on record. Those that are exculpatory, he expunged from the record. My brother, is that how to treat a fellow Ghanaian? Is that how to apply the law fairly? Senna, is that how to do it?
Counsel, we have to bring this to a close. But before we do that, just briefly, your views on the special prosecutor's move yesterday, declaring Ken Ofo-Addo as a fugitive.
Senna, I'm not old. But I've seen a lot in life. I've seen a lot. Do you know that The prosecution of Akufo-Addo was instigated by Akufo-Addo.
Why?
Oh, because, see, I, together with my senior, keep the Honorable Akufo-Addo, in fact, upon the permission of Speaker Michael Quick, November 2017, to Yoko. In fact, when we went to Yoko, we met Nana MP. When the Honorable Akufo-Addo explained the role he played in the ambulance, do you know what he said? He said we should take the witness, the police station, go home, write it, and bring it. For life. That's what he did. Because it was so nonsensical to even invite him. He said we should go home, write the statement. So when Honorable Akufo-Addo finished writing, I took the statement back to Yoko. From the day myself, Akufo-Addo, Dr. Ayine, we went to Yoko, it was until November 2021. Was it 2022? When government decided it should be 2021 to bring e-levy or one of them.
Yes, that's November 2020. That's 2021. Yes.
Good. So I think the budget was read November 17th or 19th.
Yes. I recall.
26th November 2021. Kabagben then reached out to us that Yoko wants to see our client as a person. So, what's the issue? Because the person has written up and spoken against the e-levy. That was the big issue. So a case that has been sitting for 4 years, no action. Look, from the day I presented the statement that we wrote at home, still, Akufo-Addo never went to Yoko again. In fact, they never invited him again until e-levy there was an indication of e-levy in the 2021 budget. And Akufo-Addo has 19th, 20th, 21st, 20th. 5 days or 6 days late, we had the invitation. And you see, these things, I was so personally involved, right? So I know how people were unfairly targeted. With everything that is going on, what I ask for is that the due process requirements to be fully complied with. Nobody's right should be what. But you see, as I look and I observe the comments from some of the NPP people, I say, hey, time is not a friend of time. Look, I woke up one early morning, I had a call from the Honorable Marissa. What is where I am? So, Amy, I'm just preparing to go to work. I go to work very early. I take my out of there. He said, rush and come to Dr. Ayene's house. I ran. Do you know what happened?
No.
Armed police officers have raided Dr. Ayene's house. You know why?
No.
As Deputy Attorney General, he wrote the opinion for the amendment transaction. And so they had come to arrest him.
For a legal opinion.
Police officers. You say?
You said for a legal opinion?
for his legal opinion.
Something that is mandated under the Constitution to do.
Yes, in fact, he wrote the opinion for and on behalf of his boss, the attorney.
Okay.
You know, because you are then the deputy, if somewhere comes, the minister will say, you do it for me, that kind of thing. So
Yes.
he did it. Armed police officers, do you know what they did?
No.
Raided the house fully armed, loyal. You are about to arrest a lawyer in his house. You come with armed police and gone with the children in the house. Guess what they did? They took his MacBook, took his phone, and many other things. Took this and said they were investigating. So they took even his MacBook phones and others, and they asked him of his password. He said, look, I have nothing on the phone except my professional emails and others. Right? Then they asked for the password. She gave it to them. Go. So they took the phone to London. Crew. You remember the famous Crew?
Yes.
Good. They took him to London. They took him to London. Okay? They took it to London. The name of GODWIN, as it were, investigate and find evidence of corruption on his phone. They did the same thing to Akufo-Addo, did the same thing to Francis Dada, did the same thing to this man, the Honorable Timapo, my minister, in front of the 6-year-old child. And sometimes when you listen to some of their conversations, they indicated that some people are more Ghanaian. Yes. So now, because of this, I've been a bit cautious. Because I've seen it all. So now, it's not easy.
I see.
I've seen it all. Most of the high-profile matters, I was directly involved. Look, the hostility. You forgot it. I represented Mr. Kedi. Look, Mr. Kedi has been on dialogue for 19 years. He was not enough to stop anybody from prison and convict and sentence him to 4 years in prison. Mr. Kedi was living in Sawan prison to Tema, the Maritime Hospital, twice every week for dialysis. Senna, people have gone through a lot and they are very tired. Let's nobody create an impression that a different rule of set of rules are being used on any other person.
Well, that was going to be my last until I saw that you're responding to your senior Kofi Bento at the bar, who is of the opinion that by definition, a person charged with criminal offenses and tried is not a fit and proper person to hold the high office of governor. If he was not acquitted by his trial stopped, he remains unfit and not proper. We either have standards or we don't.
If you don't hold yourself, the things you tell some people will be bad. Now, let's look at it this way. Where Kofi Bento is a lawyer.
Yes.
Okay. So we wake up one morning for a client of Kofi Bento to raise this accusation against him that as his lawyer, he, Kofi Bento, overcharged him. Listen, and you know that amounts to professional misconduct,
Mm-hmm.
or have stolen money, you know, clients are supposed to put some money down. You don't commingle it with the operational business. So Kofi Bentil, as a lawyer, took the money and misused it. And so he files a case at the General Legal Council. In the course of it, evidence came, or it became clear that there was no basis for the prosecution. So there was a strong recommendation for the charges to be dropped. Okay? Guess what happened? Or what happened? I now go out saying that the mere fact that Kofi has been accused without more, Kofi is not fit and proper. Is that our law? Why should a lawyer be talking like that? Why should a lawyer be talking like that? Look, the 1992 Constitution elevated in Article 19 under the heading Fair Trial Rules. Fair Trial Rules. The presumption of innocence is not as old as humanity. A man is presumed innocent until his guilt. Now, mere accusation is enough to declare somebody unfit. And this view is being pontificated by a lawyer. I think we need to be careful and be slow. Look, is Bento aware that all these charges, so I'm not surprised. You know, Bento consulted for Dr. Barber.
Yes.
So it is the mere campaign waged by Dr. Barber. You know, there are some people who naturally become jealous of other people's achievements. And you see, in the specific case of the Yama, from 1996 to today, they've been with the Bank of Ghana and reading through the ranks. You know, they are those who get promoted on the basis of their competence. You see, there are some instances where the appointment will be political. But it somehow went through the ranks and became a deputy governor. And for that matter, look, Sana, I say no.
Thank you. Let's begin to us this morning.
Have a pleasure.
GODWIN Kujo Tamakloe is acting CEO of the National Petroleum Authority. And when he speaks about this case, he speaks about them passionately because he was involved in many of them at some point or the other. So you can